Hey, howdy, hey, you guys. Good to see you. Welcome in. Welcome in. Thanks for being here. I'm so glad everybody is here. Thank you so much for coming over from Allie's. I appreciate it so very much. This live will redirect you to Melissa's live. You're definitely going to want to check that out. What was I going to tell you guys? Well, let's get right into it because Lori's trial her hearing is long, and I want to be able to talk about that. So I'm going to share this real quick. We're just going to listen to it really, really quick. This is Victoria Goodwin, and she has been accused of conspiring with Grant Amato, who is serving life without the possibility of parole in Florida for killing his mom, his dad, and his brother. Okay, she conspired with him to murder Aaron Goodwin, who's one of the stars of Ghost Adventures. He's a paranormal investigator. She saw Grant Amato on Control Alt Desire that featured his story. You can catch that on Paramount Plus. I haven't been able to check it out yet, but she says basically she's using the Shaggy defense. It wasn't me. So we're just going to listen a little bit. Then we're going to go to the other Linda Stermer, because during lunch there was a bit of a kerfuffle, and I want you guys to hear about that. So here we go.
Charges of conspiracy to commit murder. That's her. Investigators believe that she plotted to kill her husband Aaron last October with help from Grant Amato. Remember that defendant? Yeah, he's locked up in Florida for killing his family. Now, Victoria's day in court was brief. She waived her right to have a preliminary hearing. Take a look.
Your Honor, this was set for preliminary hearing. Originally, she had invoked her right to preliminary hearing within 15 days. She's going to waive that right today. This was called off at our request, and we're just asking for a status check in 2 weeks.
All right. That's correct, sir?
Yes, sir.
Ms. Goodwin, did you hear those representations put on the record by your attorney?
Yes.
And you're agreeing to continue this for 2 weeks for possible negotiations? All right, so the 2-week date will be?
April 8th at 8:30.
Thanks so much.
Thank you.
Aaron Goodwin.
Okay, Aaron has now filed for divorce. She's in on a $10,000 bond, I think it is, or maybe 100,000. I can't remember, but she can't pay it anyway. But I'm curious if they're gonna try to plead this out. Okay, so then there was a witness who was supposed to have appeared in the Linda Stermer trial, which, if you're not aware of that trial, that is something that I've been covering. It's a retrial. All right. She was accused and convicted in 2010 of setting her husband on fire and then running him over with the van. The motive was she had been having an affair. Her husband, Todd Stermer, found out about it. And she didn't want to go through the divorce and all the things. So she decided it would be better to set him on fire. And then when he was escaping the burning building, she ran him over with the van. The defense is saying that it was an accident that she ran him over with the van, and not only that they were in financial trouble. And so Todd is the one who actually set the fire and ended up catching himself on fire and dying in the blaze, or dying. He succumbed to all of the fire. I mean, he was literally on fire, and that it was an accident. He didn't mean to set himself on fire, but there you have it. So I stream that trial every day. They start at 8 a.m. Central Standard Time, 9 a.m. Eastern. And if you are interested in that, retrials are very rare, and she got one. So that's why I want to cover it. And I think she'll be done right around the time that Lori is supposed to start.
Yeah.
Okay, you talked to
I talked to my
them?
messenger. I think it was him. I asked him, I think it was yesterday, I had to look at my messenger, but we talked on messenger, and then I looked it up this morning and it said I had a bench warrant.
Okay, you messaged one of them, or?
Yeah.
Okay.
Yeah.
Counsel, since you happen to be here, defense counsel, Mr. Mueller, since you happen to be here, she's indicating she messaged you or Mr.
No,
Kelly?
Art. I think I talked to him on messenger.
Art?
Yeah.
That would be the significant other.
Yeah.
Oh, okay.
So then I called this morning, that's when I emailed this morning when I called, or I found out, because I seen it online. I looked at
Okay. Okay. Are you on anyone's probation or parole right now?
No.
No? Okay. Anyone wish to be heard on,
Well, first of all, I have a concern about the defendant's significant other communicating with witnesses in this
Yeah.
case. He's not a party, he's not an attorney, he's not an investigator. He's a significant other, so that causes me grave concern, Your Honor.
who contacted whom?
I reached out to them.
How did you find?
I think, go ahead. I think it was me that did it. I don't know. I'd have to look at my phone to tell you for sure. Because to me, this wasn't really like that big, that significant. I think it was me that reached out to him. I don't remember. I'd have to look.
Do you know them personally, or?
Well, I mean, right, but I had heard that the trial was going on and stuff, so.
But I want to know how she knows Ms. Stermer's new significant other, because they were neighbors in 2007.
No, but I talked to him plenty of times on Messenger. Previous, like, I think it was 2019 and 20.
Okay, so for those of you guys who were caught, who were watching the trial with me, this is the Connie, if I'm not mistaken, and she was Mike's girlfriend. You know, Mike, we're gonna go bowling, and they were driving down the road, and they happened to see the Stermer's house on fire. She's the one that called 911. Okay, and the issue is she is now communicating with Linda Stermer, her current boyfriend, husband, significant other, whatever. Let me just tell you guys that go search this hearing and go read the comment section. It is lit.
I talked to Linda previously, and like a long time ago.
Anyone else?
Just like a friendly, just talking.
About the case, right?
Yeah, we didn't talk too much about the case, but a little bit. Like, in general, just like how Linda's well-being was and stuff, how she's doing since she got out.
Okay. How'd you get here today?
The deputy?
Deputy brought you? Okay. Okay, anyone wish to be heard?
Well, first of all, I'm going to ask the court to prohibit this individual from having any contact with people's witnesses. He's not an attorney. He's not a private investigator. He should have no reason to speak with anyone. If he wants to play lawyer, he can go to law school. If he wants to play private investigator, he get his license. So this is extremely disturbing and frightening that this individual is having contact with our witnesses. Especially since there's no reports ever being prepared, there's no discovery of any of these conversations being provided. I'm very upset by this, Your Honor, and I'm kind of holding back as much as I can here because this is very frustrating. The other thing is, I think at this point in time, the court needs to arraign on the bench warrant. She was validly served with a subpoena. I'm in agreement that probably a bond should be set in this matter.
Any position?
Yeah, I'm showboating right now, first of all.
Take one to know one, sir.
Second of all.
All right, let me tell you why you guys need to be missing this trial. Not only, okay, why you don't want to miss this trial. You need to watch this trial. Not only are retrials seldom granted, let's start there, okay? But the defense attorney, his name is Wolf Mueller, okay? He is spicy 25-8. And this kind of thing between the attorneys for the state and the attorneys for the defense goes on the entire effing trial. It's everything. It's also a serious matter, and I don't want to take away from that. But the spiciness, I would be remiss if I didn't tell you guys about it. All right, here we go. He just said takes one to know one.
She inquired about Linda Stermer's well-being. They were friends and neighbors for years. There's nothing wrong with that. And in terms of anybody reaching out to anybody, it came from the witness to our side. So there's no issue here. Ma'am,
so what'd you say, you live in Grand Rapids?
I do.
Okay. Is there any way to get her on the stand today?
No, I have experts that have been waiting, and I'm not going to be able to get on the stand today, so I'm not going to put her failure to appear in a timely fashion ahead of a priority of somebody who's in a professional career and is now going to have to come back. Your Honor, I would also inquire if she has reliable transportation.
I don't. No.
And I can say for the record, Your Honor, I wasn't paying attention, frankly, when she was talking about reaching out to somebody. I don't know when that happened. I contacted Ms. Calhoun a week and a half ago. She hadn't been served. And I just wanted to know, have you been served? Are you going to come? So I have to subpoena you. And do you remember what you said in your affidavit? Because I'm going to ask you questions about it. So that's the only and I don't know if she's confusing Mr. Bean with me, but that's my contact.
Ms. Calhoun, do you have any controlled substances in your system now?
No, I don't. No.
Methamphetamine by chance?
No.
Okay, what I'm going to do is I am going to set this matter for a status conference for Tuesday. Say 1 o'clock. Do you think you can get her on the stand?
I could try to make adjustments so that she can be on the stand.
Okay. I'll set the matter for Tuesday at 1 o'clock for a status conference. And ma'am, due to your failure to appear here, I am concerned at this time about non-appearance when I hear about the transportation issues as well, so I am going to set a bond.
Okay. My brother lives in Lawrence. I can live or stay in Lawrence.
Okay.
That's okay.
Well, for now, I'm going to set bond. I'm going to make it $1,000 cash or surety.
Oh my gosh.
Okay. To make sure that you show for your on time for your under your subpoena. It sounds like both sides were inquiring about using you and you didn't show.
It wasn't because I was unaware that I was needed, right? I mean, like, honestly, I've had some stuff going on in my life that I didn't even, like, my own problems.
Okay.
You know, not that this isn't a big problem, but my own issues, like serious issues. And I wouldn't just miss something because I didn't want to be disrespectful or just because I was being disrespectful to the court. I had no idea. Like,
Your Honor, our subpoena was for April 7th, because that's when we anticipate starting. So it wasn't like she missed our subpoena.
She missed yours. Okay. I am setting a bond, but the reason it's not too high, ma'am, is because we were able to get you here, but we had to get someone to get you here.
I don't have a car.
Okay. We'll have to figure out a way for transport then, okay? If you close that bond. Okay?
Over somebody else's problems. My own life is my own problems.
Okay. Ma'am, I'm going to have you tested at the jail, okay? Anything else, anyone? Ma'am, if you do post that bond, okay. If you're able to post the bond either directly or through other people, you need to report back here on April 1st at 1 o'clock, okay?
I don't have a car.
Okay. Well, make sure you're in contact with the lawyers so that they can contact you. If you don't post it, they'll contact you at the jail, okay?
That's not fair.
Okay, thank you. Anything else, anyone, on that matter?
You did order testing at the jail?
Yeah, I ordered that. Have her tested at the jail.
Are we addressing the issue of this art person speaking with witnesses, Your Honor?
I don't know who he is. Is he here?
He's here in the courtroom.
Okay.
Every day.
Where is he?
There's a gentleman back there in the blue shirt, Your Honor.
Sir, are you having any contact with witnesses in this case?
Back some time ago, I contacted her to find out an address on her and a telephone number, but obviously that changed because Wolf had it on a subpoena for her, and it wasn't able to. And she messaged me yesterday and said that she found out the cops were looking for her, and I said, yeah, because they issued a bench warrant for you.
Okay.
That's the extent of our conversation.
Sir, I'm directing from now going forward, no contact with witnesses, okay? Is he part of the defense team, or is he a boyfriend of Ms. Stermer or significant other?
He's helping our defense team with legal issues.
Okay, I don't see, is he a significant other of Ms. Stermer?
Pardon me?
Is he a significant other
Yes.
of Ms. Stermer?
Yes.
Okay. I'm going to order that he have no contact with witnesses due to the commingling there of roles. So to keep it clean, no contact with witnesses, sir. You
I
understand?
did bring it up with Mr. Kelly yesterday. I informed him that she contacted me.
Okay.
And I told him not to contact her.
Okay.
Yeah, so we've already took care of that, but I did inform him.
I can't change what the past, but going forward, zero contact, okay? Thank
I
you.
didn't reach out to her just in the beginning for a phone.
Okay. Anything else, anyone?
Just, we want to make sure it's on all witnesses.
Yes.
Because obviously he had her contact information. He's spoken to her in the past. It's not just her. We're asking on all witnesses that he does not contact any of them. Thank you.
Okay. Anything else, anyone?
No, Your Honor.
Okay, thank you.
Okay, you guys. So just so you know, for next time, for any time, a subpoena is not a request, it's a demand. Okay? You got to be there. If they tell you whatever, yes, the judge, yes, that's Connie Calhoun, Calmy Sadie. She is Mike's ex-girlfriend, the one that, called 911. So yes, you guys, 8, I will set the stream as soon as I'm done with this one. Y'all need to be there. 8 a.m. Central Standard Time, 9 a.m. Eastern. Be there or be square, because she's going to be on the stand tomorrow. Okay. Now, on to Lori. So they're about to address all the things. Remember the live that I did? And we were talking about Lori's motions. Okay. This is the hearing to address that. Now, they are in the middle currently of today was the first day of jury selection. Okay. So they took a break, and because they got through all of the jurors that showed up with the questionnaires. Okay. And they'll resume tomorrow. Normally it would be the end of day, but no, because Lori has filed motions. They have to be heard. One of them is about Nate being a witness. Yes. So yes, Tess, they were there the afternoon of the fire. They were the first 2 people who arrived. They were leaving their residence, which is like a quarter of a mile away. Okay. This is like a rural, can't even talk, area of Michigan. Okay. They are driving because they're going to go bowling. They were going to go on a date. They were going to go bowling when they saw the house fire. They stopped. He saw Linda doing all the backing up, pulling in, doing all the things with the van, right? He saw that. Then he saw Mike. She called 911, and yeah. Okay. All right. So on to Lori.
Whoever's left, as well as the people that we approved to come back from this morning's group, will come here at 1:30 p.m. We'll begin in-person questioning. During the in-person questioning, I'm going to need the full use of the courtroom, including the seats in the back. So those of you that are in the back as spectators might not be able to be in the courtroom tomorrow during the jury selection process. I'm just letting you know. Let's talk about some of these. First of all, for the record, I did get the defendant's notice of objection to the jury questionnaire that was filed on March 20th. The defendant was objecting to, I guess, the phrasing of the allegations that the state has made, and then requested that the fact that she denies the allegation be bolded and underlined it in the questionnaire.
This was utter poppycock and a ridiculous request, given the fact that it's a freaking jury questionnaire, Lori, which implies that you have pled not guilty. Idiot. Otherwise, why would there be a trial?
I did get your objection. I guess de facto I overruled the objection, and the questionnaire went out as proposed. Next I have defendant's motion in limine to preclude expert testimony of Daniel Coons dated March 10th. Let me ask the state. That's Detective Daniel Coons of the Chandler Police Department. Is he going to be testifying as an expert?
Your Honor, we did notice him as an expert in terms of his background and training and testifying as to trajectory. So we did that in abundance of caution, but we did supplement and provide the defense with the background of that. It was provided to the defense more than 30 days before trial. And defense has interviewed him since then.
What was the last part?
The defense has interviewed him since then.
Okay. So, Ms. Daybell, what's the objection?
So for 5 years, of course, he's been on the witness list to be a regular detective, and now he's being put on as an expert. I feel like to give his opinion instead of just stating the facts. So that was my main concern. I don't understand how the trajectory has anything to do with conspiracy, so I object in that way as well.
All right. Has he testified in that regard in the past?
Yes, I believe so, Your Honor. He has been trained in that area and taught in that area. And his relevance, Your Honor, would be because the defense has claimed a self-defense claim as well. It's relevant for that.
Can the state provide me what his opinion is, and does he have a CV?
He does not have a CV. We did actually put the opinion in the supplemental 15.1 that I filed, along with his, I believe, background and training in that as well. So.
I guess let me flesh this out a little bit more. Let me ask the defendant, you've said a couple different things. Are you saying he's not qualified as an expert, or just that the disclosure came in late and you don't think his opinion is relevant?
Well, one, I don't think his opinion is relevant, but also the fact that he's named as a firearms expert. So I don't know if he took a weekend class and that made him a firearms expert. I don't know what his experience was with that. In his CV, it just says firearms expert. So.
Did you ask him those questions? Was it you that interviewed him or your investigator?
My investigator interviewed him.
Do you know if he asked questions regarding his background,
sure.
training, or expertise?
Okay, so I haven't listened to that yet, so I'm not quite sure. My concern was that he was a regular detective on the witness list for 5 years, and then 30 days before trial, he's now an expert so that he can give his opinion. And I just thought that was my objection.
Well, if that was your basis of the objection on the timeliness of it, the state did comply with the rules as far as notice prior to trial and giving some sort of summary of what his opinion testimony would be. I'll take a look at it. It doesn't sound like we need any sort of Daubert hearing, but I'll take a look at it. So let's table that for now. Next I have defendant's motion to disclose 404B evidence dated March 14 and the state's response dated March 23. I don't know that the evidence that the state is offering to introduce necessarily 404B bad act per se, but let me hear from the defendant. You got her response?
I did.
All right. So what specific bad acts do you think should be precluded? Or were you just asking for disclosure of what they were actually intending on introducing?
I was asking for a disclosure of 404B that they planned on introducing at trial, and what I got was another theory of the case. So I didn't think that any of it was 404B relevant.
Well, I think I agree with you in so much as what was listed in their response, I wouldn't necessarily characterize as 404B evidence. But you have received that, and now you're aware of what they plan on introducing.
Somewhat.
Okay.
Correct.
I don't think I need to make a ruling on that. If there's evidentiary objections, hearsay, foundation, those types of things will be taken up when the state elicits or attempts to elicit that information.
So, Lori, come on. I don't like the evidence they plan to use against me. I'm going to object to all of it. That's basically this. Okay, let's keep going.
I have next defendant's motion to exclude state witnesses dated March 14 of 2025 and the state's response, specifically defendants requesting to exclude Nancy Jo Hancock, Christina Atwood, and Kay Woodcock. The state filed a response on why let me just make sure I'm looking at the right one. The state's going to offer some sort of testimony from these three witnesses that are going to talk about, to go toward the element of premeditation and or motive. So what is your objection specifically?
Mine, Your Honor?
Yes.
Oh,
No,
my
no.
objection was that.
Hold on a minute. No, Lori, he doesn't want your objection. He wants the voices in your head's objection. Pay attention, lady. Aren't you supposed to be your own attorney? You said you could do this, right? Who else would he be talking to? That's your motion, big dummy.
After their interviews, after their defense interviews, that it came to light that their information came, well, one specifically came from Dateline, and then they called each other and their information came from each other. So
I guess I'm working a little bit in the dark. What information is that?
whatever they're, I don't know, planning on testifying about, none of them have personal knowledge of any kind of crime. So
that's really not how it works, Lori. Look, let me just break this down for you. Although I am glad to see that you didn't waltz into court looking like a bootleg, cowardly lion Shih Tzu mix of some sort, kind of with the Charo hairdo. Gucci. I'm glad to see that. Good for you. You're in street clothes and whatevs. But anywho, that's beside the point. Did you not hear what the state said? What they wrote? Did you read it? Because they're laying the foundation. They do have personal knowledge of the crime. Not the crime itself, but of the acts that led up to the crime. Specifically, the life insurance. Idiot.
The state's not saying they have personal knowledge of a crime. They have personal knowledge of things that may lead a jury to infer some sort of premeditation or motive. So what information is that? Let me ask the state. Or what's your offer of proof on why they're relevant?
With regards to Christina Atwood, she is a person who was present when the defendant was speaking about the victim being possessed, which goes to, again, the motive of this as well as the premeditation, and that those statements were made months in advance of the actual murder. With regards to Nancy.
So that's going to be offered as some form of admission from the defendant.
So that would be admission by party opponent, and that's personal knowledge.
Did you say that was Nancy Jo Hancock?
So that was Christina Atwood.
Christina Atwood.
Nancy Jo Hancock is the last person that saw the victim alive prior to that. What she knew about this was hearsay, but her statements to the victim of what he should do were her understanding and expression to the victim that he should tell the defendant that he had changed the life insurance policy to stop all of this from going on. So she both sees him the night before, is aware that he's there, and then she makes statements to him regarding what he should do.
Okay. And then
Kay Woodcock is the person who actually obtained the life insurance policy, which the state is alleging is part of the motive. And she also has information relating to the victim himself. There are allegations, again, of the self-defense, the use of a baseball bat, so she can provide background on the victim in that area as well.
All right. Do you want to have further argument?
Oh.
just the fact that this information that is supposed to be coming forward is not. All these witnesses are getting together and talking about all this and comparing all their notes and all these things beforehand, and then they're telling us that in these interviews. Well, I talked to her 100 times. Well, I talked to her every day. Well, she told me this. Well, she told me that. So their information is not firsthand. These witnesses are all coming together. They're all watching everything that goes on TV regarding this, and I would like them all precluded.
Okay, well, you're always allowed to cross-examine a witness about any biases they may have about those things that you've just talked about, colluding with other witnesses. Those are all areas of ripe for cross-examination, but they're not bases to preclude a witness. The court finds that, based on the state's avowal, that those three specific witnesses do have some minimal, although very limited, relevant information to provide and could be helpful to the jury in understanding the case. So the court will deny the motion to exclude the state's witnesses. Again, this ruling doesn't preclude you from any objections you may have to, if they're testifying to hearsay or something like that. Next I have, is there a Mr. Eaton here appearing?
Your Honor, Matthew Kelly, I represent Mr. Eaton.
Okay, you filed a motion over the weekend Mr. Eaton or someone that he works with filed a motion. Mr. Eaton was, let's address that now while we have people here. Mr. Eaton was listed as a witness by the defendant. Mr. Eaton apparently is a reporter in Idaho, and based on the filings, believes he doesn't have any relevant information and shouldn't be listed as a witness. So let me ask the defendant, what relevant information would Mr. Eaton have? Why is he listed as a witness?
Well, I just got this last night, so I haven't had time to read all the things that he's claiming he doesn't. But there's several things off the top of my head that is relevant. Right now, one of the things is it's different now, right? Because he's had this off-the-record conversation with the prosecutor, and he's kind of made himself a witness. He's kind of made her a witness.
How so?
In the sense that if this is not prosecutorial misconduct, then one of them is going to have to testify and talk about how it's not.
Let's back up. How is he a witness to this trial? How does he have relevant information? Relevant information means a witness has testimony that makes some fact in the case more or less likely. So how does he have relevant information for what this case is about?
Your Honor, I appreciate your clicker. If you're drinking, if anybody's drinking or eating, I'm about to say some things, so you might want to put it down. I don't know if it'll be funny or not, but here we go. Your Honor, I appreciate the patience that you've shown with this defendant, okay? But I'm going to tell you right now, although I understood your explanation, I don't think that she did, and I think it would behoove you to bust out the crayons because she's going to need a picture drawn. She's not going to get it. Here we go. Does she get it? What do you guys think?
Okay, so initially when I put him on my witness list, my intent is because I do not know what the state is going to put on in their case in chief. And so I was calling him as a witness for the purpose of impeachment, laying foundation for interviews, rebuttal to whatever that the state might put forth, because he has interviewed almost every single witness on their witness list. And if they were to say something contrary to what they said to him on a public thing, then I would use him to lay a foundation for interviews and for impeachment. So that was my initial, in calling him. I found it funny when I read the beginning of this. He says that it seems to be clear attempt by Mrs. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. So I had to laugh at that because it hadn't even occurred to me that he wouldn't be able to be in the courtroom if he was a witness according to 615. So.
Okay, now you're just lying. You know damn right well, first of all, Miss Lori, since I'm sorry, let me refer to you by your full name. Lori Vallow Daybell, Esquire. Let me just point it out to you. Nate Eaton would only be allowed to testify that he interviewed these people. He would not be allowed to testify to what these people said during the interview. How do you not understand this? Oh, Justin, thank you so much for becoming a member. I know that other people have sent milestones. I miss them, like highlighting them because I just wanted to get into this, but I appreciate that your support so much. Thank you so much, all of you guys. But yeah, that's what we're working here. Lori, oh God, here we go.
So that wasn't my intention. It was never my intention to do that. It was just to have him on hand if we needed to do that.
All right. Mr. Kelly, right?
Yes, Your Honor.
Mr. Kelly, in theory, it sounds like if a witness said something different than they reported to Mr. Eaton at some point, I guess in theory she's right that Mr. Kelly could be called as a witness to impeach someone, but that's only allowed after the person's confronted with the actual statement that was made, and if they then deny that statement that was made. Do you have copies of his interviews and transcripts of interviews that you might want to impeach someone with?
Hold on.
I've been watching most of the interviews and I take my own notes, so yes.
Okay, Lori, you think you're a goddess. I don't think that your notes are credible. That's all.
Go ahead.
Your Honor, two things. One, excluding Mr. Eaton under Rule 615 would be a violation of his rights under the First Amendment to attend and report on this very public trial. But more importantly, Your Honor, if Mr. Eaton were to be called as a witness, the party calling him would have to comply with ARS 12-2214, which has very stringent requirements for subpoenaing and compelling the testimony of a journalist about information that that journalist has obtained in the course of news gathering. As we state in our motion, we don't believe that there is any way that Ms. Daybell can meet those requirements, but I would suggest that if she wants to call him as a witness, she would absolutely have to follow the requirements of the subpoena law, and we would then have an opportunity to challenge that. But we don't believe that there should be any reason for Mr. Eaton to be excluded from the courtroom.
All right. I'm just thinking through this problem. If a witness got on the witness stand and said something different in testimony than you saw on an interview with Mr. Eaton, you would then play that interview. You wouldn't even need Mr. Eaton to do the impeachment because you could impeach them with the interview.
Now, isn't that what I just said? Keep in mind, folks, that your girl over here has a good enough diploma. And I'm not even the one sitting in the courtroom who just told God and everybody that, she's can totally handle this. This is no big deal. She has totes got this. Idiot.
By playing it for them in court or something like that. So now that I'm kind of thinking it through a little more, I'm not sure.
And I wouldn't need him to lay that foundation for the interview?
I'm really trying not to give you any legal advice because you are acting as your own attorney, but if the witness admits that's them on the interview and that's their statement, that is foundation. So
He's interviewed law enforcement, almost all the law enforcement that's going to be, up here on the stand. So it's not just witnesses, it's law enforcement.
Well, when I say witness, I mean generally any witness, regardless.
Lori doesn't understand the term witness either, apparently. My gosh, this is going to be the best trial. Although, let me just say this. This trial is going to be, from Lori's side of it, an absolute dumpster fire because of who she is and the type of person she is. And while there's a part of me that is wanting to see that, I'm also saddened by it because the truth is this trial is supposed to get justice for Charles Vallow. And I think she's making a mockery of the system, and that makes me sad and it pisses me off.
Regardless of their occupation. So I don't foresee, I see it in only the narrowest of situations where he could even be called to as an extrinsic person to testify about the impeachment. You'd have to jump through a number of hoops before that as far as presenting the witness what the statement is, and depending on whether they admit or deny that it's them on that video or interview or whatever the case may be that you're referring to. But I'm inclined to strike him as a witness at this time, allow him to be present if he so chooses in the trial. But then again, if you wanted him as a witness, you would need to subpoena him. But at this point, I'm going to strike him from the witness list and permit him to be in the courtroom. If there's a situation where you think something has happened during the trial where you think he should be called as a witness, I guess we'll cross that bridge when and if it comes. Okay?
We could just call him up from the back?
Well, we'll address it when and if it comes, yeah.
And Your Honor, I would ask that if that were to occur, that I would be notified and given a chance to appear and be heard.
Well, everyone will get a chance to be heard if we cross that bridge. I just don't see us crossing that bridge, but I could be wrong. So at this time, it's sort of striking Nate Eaton from the witness list. He can be present if he so chooses in the courtroom.
Yay for Nate!
Right, thank you.
Because I don't give a rat's.
Let's go next to the state's motion.
What Lori says, she absolutely, totally, 100%. She knew exactly what would happen, and that's why she wanted to call Nate as a witness, to keep him from being able to sit in the courtroom during testimony and being able to report on the trial. That's it. That's all. Stop playing with these people, Lori.
To preclude media from displaying or disclosing phone numbers and email for witnesses and victims. I guess I have no problem granting this in concept, but let me ask the state: are these
Justify as to? So my concern, obviously, is there are.
We're just going to skip this part because this part is, look, they don't want their witnesses, their phone numbers and their email addresses because there's communications between Lori and some of these witnesses, or Charles and some of these witnesses. That's it. That's all.
Both have attempted to not be part of the media. and have not given interviews and would not want their information to be out there, given that this is being live streamed, having their phone numbers or...
No, we agree.
So we're not actually being live streamed, but I'm going to order that. That's another thing. So going forward, okay, all the trial every day will be there'll be a 30-minute delay. So it'll be live, but not live. The feed also to have the ability to find an entire phone number or use and preclude noticed witnesses. Did Mr. Dworkin ever get a report? Let's go to. This is about to get real good. State's motion to preclude Lonnie Dworkin and preclude noticed witnesses. Did Mr. Dworkin ever get a report prepared?
Not that the state has received.
Do you know? Oh, Mallory, thank you for being a member. Why is it taking you so long? Let me say this. So remember how we talked about how long this trial was going to be? This is why it's going to be so long. Because Lori has to discuss everything with her counsel.
Okay.
It's going to be 5 ever.
Your Honor, most likely, we're having an affidavit sent over from Mr. Dworkin tonight. He has found a discrepancy in the information that he downloaded and the information that was turned over initially by the state, and he wants to explain what that is and how that will be relevant. So if we get it tonight, we'll forward it immediately to the state, of course, tonight. He was working on a bunch of cases, and he's doing the best he could to include our case and get it done as quickly as possible as when he was assigned from OPDS.
Well, at this time, I'm inclined to preclude Mr. Dworkin. Granted, something pretty extraordinary happening. I offered you a continuance last time we were in court in order for you to explore that possibility. You declined the continuance. So it's any disclosures late at this point. I'm not going to slam the door on it completely because he may or may not have anything that actually ends up being useful. But at this, depending on what he actually has, we can talk about it. But at this time, he's likely to be precluded as a witness because the state wouldn't even have an opportunity to have their own witness or rebuttal witness look at something prior to trial. But again, depending on what you have, we can talk about it again.
Okay.
The rest of your witnesses, we've already talked about Nate Eaton. I don't know if we need to go through each and every witness, but I think where I need to start is if a witness hasn't been served with a subpoena to appear in court, there's no requirement for them to show up for your trial. If they have been served, they would need to submit to an interview with the state in advance of their testimony. And then the third aspect is they need to have something relevant to testify about, which relevant, I told you a little bit ago, means they have a testimony that's not based on hearsay, that tends to make either a fact more likely or not. So why don't we go through, I'm trying to compare your witness list to the state's motion. Let me see here. So Nate Eaton, as of now, is not a witness. Next we have, I don't know how to pronounce her name. Is it Viasia?
Vicia.
Vicia.
Ita Iha.
Is this one of the ones the state was able to get a hold of?
No, Your Honor. We did call the numbers and left voicemail. I've not had any response, and it's my understanding that when I interviewed the defendant's investigator, Jeff White, he also was unable to speak with her.
All right.
Lori's calling people that she doesn't even have the right number for them.
What about Gabriel Bonilla?
Oh my.
Your Honor, I had an update on that one in the sense that on Saturday, so when the state interviewed, again, Jeff White, the defendant's investigator, he had not been able to speak with Mr. Bonilla. I also called and left a message on the phone number that I received from the investigator. On Saturday, the attorney for Mr. Bonilla called me, and Matthew Ballard, who represents the Church of Latter-day Saints. He advised me that Mr. Bonilla has not been served with a subpoena, but I did not speak with Mr. Bonilla or was not given an option to speak with him.
So we don't know if that person's been served or if they have relevant information.
According to the attorney, Matthew Ballard, he has not been served.
All right.
Lori,
What about,
who is he?
well, why don't I just ask the state? I've got your supplemental and your other one. I know you've actually talked to a few of these people on the phone.
Correct.
Is there anyone on this list, and I'm looking at the defendant's supplemental 15.2 filed March 12, on page 2, there's a number of witnesses listed out. Is there any on this list that you have talked to that you don't object to being called?
Your Honor, I think that there is potentially minimal relevance from Summer Shiflett.
Chislett?
I think that's a misspelling
Oh.
of her sister's name.
Okay.
I think there's potentially minimal relevance for Janice Cox, her mother.
Okay.
Adam Cox is actually on the state's witness list, so we don't object to him. I did speak with Zachary Cox. I'm not aware of any relevance as to this case from him, but I did speak with him.
I see in your pleading that he advised you he's not been subpoenaed.
Correct. Everyone I've spoken with has not been subpoenaed.
All right.
Your Honor, our subpoenas are with OPDS right now, and they should be being issued currently. The state talks about in their response, like, the state is claiming trial by ambush from the defense. Trial by ambush. How is the defense trial by ambush when they have interviewed every single one of these witnesses before in the last 5 years since this case started? They've interviewed every single person that has been on there. They have written, transcripted interviews and video interviews of all of these people. And so how they are relevant, these witnesses will testify if and when they are needed to add additional facts or fill in the blanks that the state will no doubt leave out in their case in chief, and they'll be called accordingly. I need them to lay perhaps foundations for evidence presented by the state. The same with Lonnie Dorkin. His testimony will be required if and when it's necessary to rebut digital information that the state will bring forward during trial. I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not gonna let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
All right. Well, that's why attorneys sometimes take a long time to prepare for a trial, because they need to give notice of what all the testimony their witnesses are going to give. They need their experts to prepare reports. That's why your prior attorneys and your current attorneys were asking for more time to prepare the case. So you can't really have it both ways, that you want your speedy trial rights, but you don't want to give notice to the other side of what your evidence is.
I don't not want to give notice to the other side with the limitations at the incarcerated state where I am, and the limitations with OPDS of getting Lonnie Dorkin late in the game that they did. I've done everything in my power as a defendant to prepare the state and to give over everything that I could do within my power, with the limitations that I am an incarcerated person at this maximum security prison jail.
So when you say...
And I shouldn't be able to represent myself because of that fact? That negates my constitutional right?
I didn't say that. All right. I said that sometimes there are reasons to not go forward to trial as fast as you want. All right. So when you say things like they're going to fill in the blanks, that makes it really hard to assess what their relevant information is.
They have relevant information to a lot of factors that I got in the 404B information. For example, the life insurance. My father is a life insurance salesman. He worked with Charles on getting both life insurance policies, my $2 million policy and Charles' $1 million policy. He also tried to sell my insurance policy after Charles passed away. He also told me to go to call the insurance policy and said how to do that, how to call them when you're the beneficiary. I didn't know how to do any of those things. He has relevant information to that. My sister.
Wait a minute, Lori. Back the milk truck up. Just back the milk truck up. You don't know how to work a phone? Come on. We heard you and Melanie. We also saw all those texts between you and Chad and those phone calls. Oh, excuse me. I didn't mean to burp. Between you and Chad. You know how to work a phone. What do you mean you don't know how to call the insurance company if you're the beneficiary? Stop it. Also, Lori, use your inside voice. Now, to be fair, I do have her sped up to 1.25, but I haven't changed her volume. That's her volume, okay? And she's a fast talker anyway. But what he's trying to tell you, nobody's trying to take your constitutional rights away, Lori, although you took away JJ's constitutional right to live, to life, liberty, and the pursuit of happiness. You violated that constitution, his constitutional right. You violated Tylee's same constitutional right, and you violated Charles Vallow's constitutional rights. So nobody really cares about your constitutional rights, but you still get them. All right. What he's saying is you have to weigh your options. Is it better to go forward and have a speedy trial, or when the state clearly has all of their I's dotted and T's crossed, or should you waive your right to a speedy trial in an effort to build a better defense? You clearly chose the wrong avenue, and now this is what we're left with. So if you're mad at anybody, you need to be mad at you and not other people, and stop being disrespectful to the judge. We don't appreciate it.
Has relevant information to my brother Alex Cox and the whole situation of what happened on July 11th. These people have relevant information to the state's case, what they're accusing me of. There's very relevant information from a lot of these witnesses.
So what I'm struggling with is you just say.
I'm sorry, Your Honor. I didn't mean to interrupt you, but I need to understand how how a bishop from the LDS Church. Thank you for pointing that out in chat, Marjorie, because I forgot who he was. But how is a bishop from the LDS Church gonna fill in any freaking blanks? Explain that one.
Saying that it's relevant doesn't actually make it relevant. It may be relevant. I'm trying to find out the relevancy. What you said about your father being an insurance salesman and selling policies, that sounds relevant. It could be relevant to me. Who's your father? I don't know who your father is.
Barry Cox.
All right, Barry Cox. It sounds like even from what you're saying, though, you're not, depending on what the state produces at trial, you're not sure that these witnesses would have relevant information. It just depends, is what it sounds like.
Whatever they put up in their case in chief, am I not allowed to try to defend myself against that?
You're absolutely allowed. I'm just trying to figure out, I'm sort of a gatekeeper, and I need to make sure witnesses have relevant information. And just like you have the right to interview all of the state's witnesses, excluding victims' rights, people that can deny having an interview, they have the right to interview all your witnesses prior to trial so they can have an idea of what those witnesses might say on the witness stand.
I understand that, Your Honor.
So
they also have already interviewed all of them.
I'm not talking about police interviews or interviews that may have been done years ago. The prosecutor has the right to interview any witness prior to them taking the stand, just as you do. So I'm not sure the best way to handle this other than
oh my God,
maybe we should take it up as we progress through the case, but
Your Honor,
some of these people may or may not be even served.
Yeah, my concern is obviously I have attempted to reach these people. I've made my good faith effort. I've been told both by myself in attempting to contact them, as well as the defense investigator, that they've been unable to reach them. So it seems to not be following the rules of procedure or evidence to then bring up later on if they perhaps find these people at some point, then the state can try to at that point preclude them. When the state talks about a trial by ambush, it is in fact that. When the defense investigator themselves cannot find these people and are still looking for them in trial when they've had at least, we'll say, 4 months to try to find them, I think that at this point, precluding them is proper.
Well, I would preclude anyone that doesn't submit to an interview with the state. I kind of want to punt this a little bit just because if there's people that don't end up getting served, don't end up showing up at court, they can't find, then we don't need to waste our time talking about whether or not those people have relevant information because they're not going to be here and they're not going to testify. So I'm putting the defendant on notice that if these witnesses aren't served, if they don't submit to interviews, they're going to be precluded. even if they submit to interviews, I may have to make a determination whether their testimony's relevant or not. So again, we're going to, I think, have to cross that bridge when it comes. The state did say that they concede that some of the witnesses, Adam Cox, Janice Cox, Summer Shiflett, may have some minimally relevant information. The rest of these, I think we're going to have to take up maybe on a piecemeal basis, but I don't want it. It's not going to be a situation where you're ready to call them in as a witness the morning of, and then the state they haven't been presented to the state for an interview prior to that. So keep that in mind when coordinating with your investigator. If he gets them served and they're actually going to be called at trial, they need to submit to an interview in advance of their testimony.
Your Honor, I understand that, and I am limited in what I can do. If I could call these people myself, they would answer my call probably, and I could have this discussion with them. But I'm going through the limitations that I have at the jail through my paralegal who's working overtime and my investigator who's working overtime to try to do everything to help me prepare for trial, as they have other clients as well that they have to do things in a timely manner for. So we are doing the best that we can.
Okay.
Well, that falls under the category of not our problem.
All right. We next have defendant's motion to dismiss for violation of confidential communication and the Sixth Amendment dated March 18 of 2025 and the state's response. Let me ask the defendant first if you've received the state's response.
I did.
Did you say you did or didn't?
I did.
Okay.
Yes.
If you have an attorney in Idaho that is working on an appeal, it appears that the information that was turned over by the jail was some pretty innocuous messages about trying to set up the legal line to talk to you on a confidential line. And really, that's about it. So how does this arise to some sort of nefarious interception of things? Because it was put on a public chat system that the jail uses. You know it's not confidential. And you're told it's not confidential. And then even if I look at the substance of the messages, there's really nothing in the messages that would arise to some sort of confidential communication, just trying to set up a meeting and get the unrecorded legal line set up.
Who's saying that they're not confidential?
Hold on a minute. She's saying that she's innocent. She's pled not guilty.
Well, the
Who's
jail,
telling me that they're not confidential?
your own attorney, it looks like. Here's a message. I see that they came and got you. I'm working on getting a confidential attorney line set up. The implication being that this message is not confidential. The next one, again, just checking in. Hope things are getting a little better for you. I'm still working on getting a legal line set up. The implication is that these are not confidential.
Okay, so then he received a letter from MCSO that said, your phone number is now confidential and arranged for confidential client privileged communications. So from my no, it says this phone number is connected to that. So from my perspective, when I call someone on the tablet or when I text someone on the tablet, it goes to their phone number. So all the communications after the date of the exhibit that we put in our motion, when he got that letter from MCSO that now all of your things will be confidential. Okay. Now they will be confidential. So my understanding, and I'm the only one that can waive that privilege, right?
And I think after that, when his line was approved, there were no other disclosures of messages between you and him, correct?
No, there are.
You received other disclosures of intercepting messages between you and him?
So those go up to the 24th of January?
No, the only thing I saw was up to, I think, late December of 23.
Okay, so there are confidential things that are in our communications because I was not aware that after he received that there were not. So the prosecutor who obtained these, her protocol would not be to stop and ask the court for some guidance on this, maybe do an in-camera review if she's subjecting herself to client privileged communications, instead of reading them and finding out and assessing for herself if there are anything in there that's confidential information between me and my appeals attorney. I have no other way to communicate with him when I'm in this incarcerated situation because I was brought here to Arizona to deal with these charges. So it is a problem. It's a problem that she took them. It's a problem that she got them from MCSO. It's a problem that she read through them. It's a huge problem that she put some of them into her motion, and now his IP address is exposed to the public, which is a federal offense. There's a lot of things wrong with what has happened here.
Well, you reminded me that when his number was approved, he then sent messages from different IP addresses instead of that phone number that was privileged. So he's the one that disclosed or violated the confidential nature. I don't see that any of these, I'm going to call them inadvertently intercepted messages between you and your appeal attorney. I don't see that they're being used in any way by the state.
Just the state reading them as a violation of the client-attorney privilege.
Well, not if they're not done through a privileged setup the way that they were supposed to, which he even acknowledged.
My understanding from my perspective was that that phone number was now privileged. The way it comes to me on the tablet is I text that phone number or I call that phone number.
Correct.
So,
if you're communicating through the phone number, but if he has it set up where the messages aren't being sent and received actually through the phone number, but through different IP addresses, the system doesn't know that they're privileged because they're not being sent and received through that privileged number.
but I didn't know that. There's no way for me to know that from where I am in my cell. There's no understanding for that.
But your attorney does.
I
So
thought-
the violation isn't, the issue here isn't the prosecutor, it's your attorney.
I assumed he was just getting them on his same phone that we were having client-attorney privileged communications. And is the state giving these to Idaho? Do these get dispersed out? I would like to know that. Where are these going? They're getting them from MCSO. Is there a subpoena to get these from MCSO? Is there a warrant to get these from MCSO? I didn't see
No.
anything.
Let me just say this. No. Anytime that you use the jail system, whether it be a tablet or a phone call, you big dummy, which they tell you 11 billion times every time you call somebody, they're subject to recording and monitoring. What do you think that means? Jeez.
That warrants them getting them from MCSO in the first place.
All right, let me hear from the state.
Your Honor, I think that the state's motion really covers the law under this. The defendant and her attorney were provided with information, whether or not she understood it or not. Her attorney understood that it was phone calls that were covered. So it's not just the defendant who is not complying with following the correct procedure to utilize the set up attorney-client privilege means to communicate. In this case, the state, obviously, I disclose those before I even look at them. I understand that they are statements by a defendant, and I believe that they are to be disclosed under Rule 15. And so before I even look at them, I send them to the defendant because I don't have the option of not providing them to her since they have been obtained. I think if you apply the case law in this, the defendant cannot meet her burden to show that there's any legal advice in these messages. There's no privilege in them. The messages are asking to set up times to call and to speak.
Are the three, I think it's 3 messages that you included in your response, are those all the messages?
No, Your Honor, there are other messages, and we do say that tablet messages between Ms. Daybell and Mr. Jerem do not end on December 28th. They continue.
And there is privilege information on them going forward. And the state is basically testifying for my attorney now. She just testified for my attorney that he understood that that these were not privileged communications. Where does she understand that where is she testifying for my attorney?
Well, I think because of the context of the messages say, I'm trying to schedule a time and I'm trying to set up a confidential line, meaning
That was
this
before.
is not confidential.
That's right. He said it wasn't confidential before MCSO gave him a letter saying your phone number is now confidential. Your phone number.
Lori, is your attorney, your attorney is your appellate attorney, right? So if it's your appellate attorney, that means that your attorney deals with clients who are currently incarcerated. So if your attorney doesn't understand the process and that, it's one phone number, they're not going to use 11 billion different numbers and IP addresses. That's not how it works. And if your attorney doesn't understand that, then that falls under the attorney's problem. That's an attorney issue. That's something you need to take up with your attorney. That does not make Trina K, the prosecutor, guilty of prosecutorial misconduct. Stop playing with these people, man. Just because you think it doesn't make it so.
I'm not going to keep rehashing this with you. The fact that he's using different IP addresses and not messaging through the actual phone number that's protected, I think is part of the problem. So if he's not using the program correctly, that's an issue you need to take up with your attorney.
How is he using it incorrectly?
I just told you. He's not messaging through the phone number. He's using different IP
How
addresses.
can you message other than the phone number? I don't understand that.
I don't understand that either. But if it was from the phone number and it's for his cell phone, for example, it would be the same IP address for each communication. There's like 4 or 5 IP addresses.
Where are the IP addresses coming from?
Oh,
they're given to you by the state?
No.
They're right there listed on the messages.
Oh my God.
I'm just saying, where are they obtaining those from?
Where are they obtaining what? Everything is tracked, you idiot.
From your attorney's messages to you?
From MCSO?
Yeah.
Did they get IP addresses for every single person of every single message communication on the text from MCSO?
Well, it's listed on the messages, so I assume so.
Yes, Lori, yes.
It says Craig Durham, and then under it is the IP address from the device that's being used.
Okay, and then Ms. K is reading all of these messages and they're not privileged. Is that what you're coming to?
They're not privileged if you're not using the program or your attorney's not using the program correctly. Okay, they're still not going to be allowed to use any of these messages. What I'm saying is they're inadvertent disclosure by MCSO because someone's not using the program correctly doesn't mean that they had bad faith in how they got them. They made
How is he using it incorrectly?
I don't know how else to explain it to you. I've told you 5 different times now. So
Get the crayons, Your Honor. I told you you were going to need crayons. Here we are.
he's not messaging with the phone number. He's messaging from different IP addresses.
Okay, can I ask if these messages are being disseminated anywhere to Idaho, to the prosecutors in Idaho? Because that's definitely affecting my appeal if that's the case.
I don't know.
Have not been sent to anyone other than the defendant, Your Honor.
All right. So there was some communications I find that were intercepted between Ms. Daybell and her attorney. The state's not to use those communications. They're not to disseminate those communications, but I do find that they weren't purposely sought out by the state.
We need a palate cleanser. We do. Lori is doing too much. Here, Lori, this is for you. Where's it at?
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
And that dismissal isn't the appropriate sanction if there is an appropriate sanction. It's order denying the motion to dismiss for violation of confidential communication. All right, then we have defendant's motion to dismiss for prosecutorial misconduct dated March 21st. Let me get that.
Hey, Michelle, I still go live, babe. I've just been
And
doing
the state's
it.
response.
Hold on. I've just been doing it during the day because I've been streaming trials. So I've been streaming in the mornings. I miss my nighttime viewers too. I just don't know how to fix the situation. Perhaps you guys could tell me in the comments. I'm open for any suggestions.
The motion to dismiss for prosecutorial misconduct was filed on March 21. The response, I don't see a date on the response, but I do have the response. Did you get that response?
Have it.
Come on, Lori.
Ms.
He's
Daybell,
talking
did you
to
get that
you.
response?
I did, Your Honor.
All right. So your prior attorneys had, actually, let me back up. The state filed a motion back in, I think it was September of 2024, asking the court to preclude your defense team at the time from making public records requests through Gilbert and/or Chandler police departments. I denied the state's request saying that the defense is free to do their investigation and make public records requests through appropriate means. So that's part of your complaint, that they didn't provide those public documents to the defense. That's sort of a civil issue, I guess, but let me hear your argument on that.
That isn't really the complaint itself.
That's your first paragraph.
I know, but the complaint is that
I'd like to take each allegation and deal with them one at a time.
I understand
that's
that.
your first
My
allegation.
complaint is the interference by the state, Ms. Kay in particular, in stopping that and interfering with us trying to investigate and do our own investigation. It is a violation of the constitutional right and due process. And she did do it, and she did do it purposefully. And then after she did it, and we weren't allowed to have anything from either of the police departments, then she filed her motion. And then later, the day that I was Rule 11, that is the day after when you said that you denied that motion. So I don't know what she did or what she said to Chandler and Gilbert to stop them from giving us any information. But as soon as we put in a request, we were cut off. No information. You can't have anything. That's when I was trying to, the big video that we're trying to get in Gilbert, that's what I was trying to request. I tried to request that myself because I would have my investigator to go and explain what that was and why we didn't have it. And so we were precluded from doing all those things by the state. They should not be interfering with that. That's one of the reasons why everything has taken so long. We haven't been given things we've asked the state for. We haven't been given them. We tried to get them from Chandler and Gilbert. We can't get them from them. She's stopping us from getting from them. How are you supposed to put together a defense?
So when your prior defense counsel put in that request back in September, the state says that they obtained those information and gave it to your attorneys on October 1. So why are we waiting until March to address this if you had an issue with that?
I have had an issue with it the whole time.
So why didn't you file why didn't someone file a motion back in after, December, November, January, February, saying they had an issue with this?
I did. These are in my motions to you for specific discovery. I discussed this exact problem.
Okay. Well, now you're saying it arises to prosecutorial misconduct.
It is.
This is the first I've been made aware of that, as far as I know, that the police department never honored the public records request. If they don't honor a public records request, there's a process to go through regarding that.
Which is what?
I'm not going to give you legal advice. All right. Your second allegation, the prosecutorial misconduct, we've already kind of dealt with, that she distributed the state distributed attorney-client privileged communication. We've discussed that. The next one is legal advice to defense witness Nate Eaton. We've somewhat discussed that, but I think their motion, the state says that they simply notified him that he would need to be served with a subpoena to have to appear in court. So how is that improper?
It's taking her word for that that's what happened. She's not under oath saying that that's what happened. Nate Eaton's not here to testify that that's what happened. They're the only two parties that are there to say that that is what happened. So that is my problem with it. I would like for one of them to get on the stand and say exactly what happened in that conversation. And
Wait. Back the milk truck up, Lori. So because they had a conversation, you are assuming that they were cahooting cahooters? Do you have any proof of this? You want to get them on the stand and have them testify under oath that they were not cahooting cahooters? Will you believe them then? I mean, this is ridiculous, Lori. You're wasting a bunch of time for nothing.
and that she wasn't giving him legal advice. How do we know that she wasn't? It's a very curious situation that he called her, and then he writes in his motion this statement that obviously comes from Ms. K. She seems to be a clear attempt by Ms. Daybell to use the rules of criminal procedure as a pretext simply to keep me out of the courtroom and interfere with my ability to report. We also don't know if he told her, don't come to the March 18th hearing because that's when they're going to serve you with your subpoena.
Okay, Lori, let me just say this. People don't get up in the morning with you're not this important, all right? That they get up and they think, how can we F with Lori Vallow Daybell today? That's not how this works. Everybody suspected that the issue of you calling Nate to be a witness for the defense was to keep him out of covering the trial, okay? Everybody did. And I didn't talk to no prosecutor. Stop it.
So all these things come from there, and we don't know who's saying it, and you're just taking her word for it, like you took her word for, oh, there's only 6 emails and there's no other emails. You're just taking her word for it as an officer of the court, and I think that she should have to be sworn in.
Well, you want me to just take your word for he must have gotten these things from Ms. K, okay? Just because his motion says he thinks that you're noticing him as a witness to keep him out of the courtroom? I don't know why you take the jump to that is coming from Ms. K as opposed to his own volition. He also hired an attorney that said the same thing. Even if she had said you need to be served with a subpoena to have to show up in court, that is not an ethical violation.
Well, giving legal advice is an ethical violation. Is that correct?
Stating what the law is not an ethical violation. If she said, I don't think you should show up at court, even if you're subpoenaed or something like that, that could be an ethical violation, but we don't have that.
How do we know we don't have that? That's my question. How do we know what went on in that conversation if it wasn't recorded? Aren't witness
You can interview
interviews
him.
recorded?
You can interview Mr. Eaton. Your investigator can interview Mr. Eaton. So when and if you get that information from Mr. Eaton that something nefarious happened in that conversation, bring it up then. But you're jumping to conclusions. You have the right to interview any witness, okay?
Not a witness anymore because you just precluded him.
All right. You can interview him. You can have your investigator interview him.
So even though he's not a notice witness now, we can still interview him and try to find this information because we can't get it now? Is that what you're saying?
Sure. Have your investigator call him. Ask him about the conversation. At this time, I'm going to, based on just the pleadings, I'm denying the motion to dismiss for prosecutorial misconduct.
Of course.
All right, 609 motion. The state's alleged a total of 7 felony convictions in the state of Idaho. Under Rule 609, the court finds that limiting the number of convictions and the nature of the convictions to be appropriate as to not be overly prejudicial. There is an interest in allowing a jury to know that the defendant's been convicted of at least 1 felony. But let me hear, I'm inclined to probably limit it to 2 felonies in order that they be sanitized. Does the state want to be heard on that?
Your Honor, I do believe that the court should allow for at least 3. There are multiple dates and multiple victims in those and multiple different distinct incidents. And I believe that it would be appropriate to, when we're talking about the credibility of the defendant, to allowing in 3 of those.
I looked at the date ranges and I looked at the actual counts, and some of the counts, obviously the laws are titled differently in Idaho, but there's a couple of counts that specifically have what I would call dishonesty built into the name of the conviction, the first-degree murder and grand theft by deception. Those are counts 1 and 3 specifically. And again, these only become relevant if the defendant chooses to testify. I did read the defendant's response asking that all of them be precluded. Let me hear from the defendant.
One second, Your Honor.
Are we going to be getting this done anytime today, Lori? Like, come on, bro. You're supposed to be prepared.
Your Honor, I haven't had a time to, I wasn't planning on talking about the 609 today, so I'll just refer to my reply.
Well, we can table it till later in the trial because, again, it doesn't become relevant unless you choose to testify, but you know my inclination and what the state's argument is.
Okay.
This morning I handed each side proposed preliminary instructions. We don't need to discuss those now. but depending on tomorrow how far we get in the jury selection process, maybe you can be prepared to tell me if you object to any or if there are additions or corrections that need to be made. All right, I think that's going to be it for today, but let me check with the state. Is there anything else we need to address today?
I think just for the record, Your Honor, in terms of allowing in witnesses, the gallery, I think that you had indicated you would reserve one row for the next of kin.
Yeah, let's discuss that. We're going to put up signage after we complete jury selection. So the first row on both sides behind defense counsel and behind the state will be reserved for immediate family members, next of kin. For today.
A couple of things, Your Honor.
Oh, wrong thing. Sorry.
We need to discuss the
how the division would like the media exhibits.
What?
How the division would like the media exhibits if we're presenting recordings or audio, individual flash drives for each exhibit. There wasn't.
Depends on how you're going to present them, but I would say, yeah, probably one flash drive per recording or exhibit.
And then I'm guessing 3 copies, one for state, one for.
I don't know that you need copies if you've already disclosed it to them. Just tell them what it is when we're marking it and tell the clerk what it is with the description so it's clear on the exhibit list which exhibit is what.
One more thing, Your Honor. I wanted a clarification in your minute entry dated the 25th regarding the defendant's motion to remove restraints. So my understanding when I read what was from MCSO, and then you put in here, however, at the sheriff's discretion, one or more armed sheriff deputies may be positioned near the exits. So what their recommendation was the minimal amount of restraints, meaning if there was going to be an armed guard, then they would not have to do the belt. So I was confused by and wanted a clarification on what you were actually ordering because the DOs had a question about it with me this morning. So
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want additional deputies.
well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order.
So what is it exactly?
Oh my God.
That you have to wear the rack belt, but not the leg restraint.
Did you not?
And that they will or will not have armed guard?
It's up to them.
Are you, Lori, why are you asking this? Are you going to try to escape? You know they're going to shock you, so just stop. Lord.
All right, so tomorrow we're going to start at 10:30 with going through the answers
All right.
on the question.
That's all that I have for you guys tonight. I want to thank you very, very much for being here. If you haven't done so, give your girl a thumbs up on the stream. I would appreciate that so very much. Don't forget, this live will redirect you over to Melissa's. You don't have to do anything. However, should it not happen, make sure you're on top chat. There should be a little box that will pop up and ask you if you want to go. Click yes if you do. Obviously, no if you don't. But you should definitely go over there and check that out. Tomorrow morning, 8 a.m., day 3, Michigan versus Linda Stermer, the retrial. Be there or be square. All right, you guys, have a great rest of your night. Thank you all for being here, and I will see you all later. Bye, you guys.
Cause it's Friday, you ain't got no job, and you ain't got shit to do. Well, fuck you.
No malicious contempt or effort was towards it.
No malicious.
Finish her.
minutes later.
We all do a little mad sometimes.